Good morning, everybody. Welcome back to the Court of Random Opinion. My name is Lauren Neidigh. We have a motion, or not a motion, sorry, an order from the judge this morning in the Justin Baldoni versus Blake Lively, Ryan Reynolds legal saga. This is pertaining to the phone record subpoenas that they have been going back and forth on. We do not have an order yet in regards to the protective order. So this is just for the subpoenas. Give people just a little bit to possibly filter in here. So we'll wait 1 minute before we start reading this, but it's a very short document, so we don't have to worry too much about time or anything. I will tell you this motion was denied in part and granted in part. So unfortunately, though, it's not like the best outcome, I don't think. So we'll explain when we get there. All right, give me 1 second, guys. As far as the protective orders go, I'll double check right now, but like I said, it doesn't look like they've been ruled on yet. It is only 10 o'clock. So, also, I wanted to let you guys know that yesterday I was trying to figure out the dates for when everything was due. And I said today there was a response due. I thought it was the motion to dismiss, but it was actually the New York Times response to the amended complaint. So I'll be looking out for that as well on the docket. Let me show you where I'm getting this stuff. If you haven't seen it yet, this is Pacer. I'll move my head if I can figure out how. There we go. So here on the docket this morning, you can see. Yep. So this was just entered this morning. Granted in part and denied in part. And it's going to explain everything in the document we're going to go over. It's like a 6-page document. It's nothing crazy. So we'll wait, and I'll keep an eye out for that response from the New York Times, as well as the order regarding the protective order, which is all that stuff that was going back and forth. Blake was talking about content creators and Candace Owens and Perez. So okay, let me pull up this document. And guys, as always, I will post this on my Twitter page and on my YouTube page after the stream. So you don't have to worry about finding the documents or anything. All right. Nope, that's not what I meant to do. Sorry. Okay, let me zoom in a little bit. Hopefully you guys can see okay. Give me just a second. Okay. Good morning, Lauren. I've been enjoying your channel lately. Thank you for your reporting. Oh, thank you. Appreciate that, Amber. It does go both ways, right? Not only the text of Blake and Ryan, but Taylor Swift. So if Justin's lawyers, if they were to subpoena phone records, then that's how they would get that. They just haven't done that yet. And this is the early stages of this case, to my understanding. So it doesn't mean that they can't get any phone records, right? It just means they haven't asked for them yet. And I'm sure when they do, Blake's side will move to quash the subpoenas, and it'll go back and forth just like they did with the subpoenas for the other side. So, hey, Lori, what's up? All right, let's get into it, shall we? Okay. Wayfarer and Justin Baldoni and the Wayfarer parties moved to quash subpoenas issued to cellular providers AT&T, Verizon, and T-Mobile by Blake Lively. For the reasons that follow, the motion is granted in part and denied in part. Lively served the subpoenas on or around February 12th. The subpoenas requested all documents concerning ingoing and outgoing calls or text messages related to telephone numbers belonging to certain Wayfarer parties and related individuals within the time period of December 1st to the present, including but not limited to call logs, text logs, data logs, and cell site location information. The telephone numbers of the Wayfarer parties and related individuals are identified in the subpoenas, but the destination telephone numbers are not. On February 14th, the Wayfarer parties moved to quash the subpoenas as overly broad and invasive. The court ordered the parties to meet and confer and report back to the court whether any dispute remained by February 24th, which was earlier this week, and we know they obviously did not agree on that. So what does this mean here? Hang on. Telephone numbers of the Wayfarer parties and related individuals are identified, but the destination okay, I gotcha. So the destination telephone numbers are not. Okay. After the parties met and conferred, Lively agreed to remove the reference to all documents, remove the request for locational data, and clarified that the subpoenas seek only call logs and text logs reflecting non-content numerical information regarding ingoing and outgoing text messages. Lively has prepared modified subpoenas reflecting these changes. So they did modify those subpoenas to take out that information. So, like the other day when we saw lots of coverage going on about how Blake kind of gave a little on these, that's what that meant. However, by letter of February 24th, the Wayfarer parties reiterated their request to quash the subpoenas. The Wayfarer parties object to the fact that, even as modified, the subpoenas continue to cover call and text logs revealing the phone numbers for anyone with whom the Wayfarer parties and other individuals communicated, regardless of whether such communication was related to the claims and defenses in this case. The Wayfarer parties therefore seek to have the subpoenas limited to communications between the subpoenaed phone numbers and other specific phone numbers of parties and witnesses that Lively would provide. Okay, so they want to make sure that they can't. They were asking, can you allow them to have the records of, say, between Justin and a specific person, but not leave it kind of open-ended to the point where they could get communications between Justin and anyone, if that makes sense. Okay. And then also the judge notes here, for certain individuals, the time period is only July 1st to the present. So people were saying it's overly broad to ask for records going back so far, like years of communications between the Wayfarer parties and whoever. So I guess for the certain individuals, it's only like less than a year's worth of communications they're getting. Yeah. Okay. So I guess when they modified them, the judge found it more reasonable, but we'll keep reading and see if he has any other reasoning here. Okay. Lively argues that the purpose of the subpoenas is to lead to admissible evidence regarding communications not only among the defendants, but among the larger networks of individuals who perpetuated the untraceable campaign against Ms. Lively, which justifies their broad scope. Lively also argues that the Wayfarer parties lack standing to assert the privacy interests of non-parties. Rule 26B of the Federal Rules of Civil Procedure provides that parties may obtain discovery regarding any non-privileged matter that is relevant to any party's claim or defense and proportional to the needs of the case, considering whether the burden or expense of the proposed discovery outweighs its likely benefit. When the party moving to quash a subpoena is a non-recipient asserting a privacy interest, the court must weigh the relevance or probative value of the documents being sought against the privacy interests asserted. Okay. And then he's citing a case here that said, the burden of persuasion in a motion to quash a subpoena issued in the course of civil litigation is borne by the movant. Okay. The subpoenas of the Wayfarer party's phone records, even as modified after the meet and confer, are overly intrusive and disproportionate to the needs of the case. Okay. The subpoenas request call and text logs between certain of the Wayfarer parties and any other phone number, in most cases from December 1st to the present. This request implicates legitimate privacy interests, even though Lively has narrowed her request to exclude the content of calls or messages. The phone records themselves would still contain sensitive information regarding which doctors, psychologists, or even acquaintances the Wayfarer party spoke to and when. I noticed he didn't say mistresses. Oh my gosh. All right. Lively has identified no means to segregate those numbers that may have some relevance to her case from those numbers that would have no relevance and would reveal sensitive personal information. Lively mainly argues that the subpoenas will help to identify the larger network of individuals who perpetuated a negative media campaign against her. But according to Lively's complaint, this negative campaign did not begin until approximately August 2024. And there's a footnote here. It says, Lively notes that an individual has no legitimate privacy interest under the Fourth Amendment in numbers dialed on a phone. However, this does not prevent the Wayfarer parties from having a privacy interest in their phone records. A privacy interest which is not protected by the Fourth Amendment may nevertheless exist, pursuant to a state or federal statute or the common law. Okay. Notably, although bank records are also not protected by the Fourth Amendment, bank records are the paradigm. How do you say that? So I know it's paradigm, but paradigmatic example of information for which a privacy interest confers standing to the object to a subpoena. Okay. And then this case said, courts in this circuit have found that individuals whose banking records are subpoenaed have a privacy interest in their personal financial affairs that gives them standing to move to quash a subpoena served on non-party financial institution. Similarly here, the Wayfarer parties have a privacy interest in their communications with non-parties, even though this interest is not protected by the Fourth Amendment. All right. So here we're talking about, she argues the subpoenas will help identify the large network of individuals who perpetuated a media campaign relating to the beginning of a plan to destroy her reputation, as if she didn't do that herself. It is therefore unclear how communications to and from Wayfarer parties in 2022 and 2023 would reveal individuals who participated in the campaign. That makes sense. More generally, Lively has not provided a basis to believe the broad discovery she seeks will reveal information regarding unknown participants in the negative media campaign proportionate to the burden on the Wayfarer party's privacy interests. Okay. Lively's complaint already identifies many individuals who allegedly participated in a negative media campaign. Lively may make discovery requests tailored to those individuals. She is permitted to use the tools of discovery to identify the contact information or telephone numbers for those individuals. Even assuming additional individuals participated in the alleged campaign, the hope that discovery will turn up information on such participants does not justify the broad scope of the subpoenas. The subpoenas must be quashed to the extent they seek the phone records of the Wayfarer parties. This ruling is without prejudice to the Lively party's service of modified subpoenas more narrowly tailored to reveal relevant information. So he's not quashing the subpoenas entirely. Like he's saying this isn't regarding the overly broad subpoenas, but not the ones that were modified. And here's the part where he denies Justin's request and the Wayfarer party's request. It says, however, the Wayfarer parties have not demonstrated standing to object to the subpoena request seeking the phone records of non-parties. A party demonstrates standing to challenge a subpoena directed to a non-party by showing that he or she seeks to protect a personal privilege, right, or interest. Okay. And then footnote 3 here says, Lively has also suggested that the phone records may speak to when and how the defendants and witnesses learned about Ms. Lively's harassment allegations. What type of information Lively seeks to discover in this regard, and how it is relevant to her claims, has not been further explained. The ruling here is without prejudice to Lively's use of subpoenas targeted to reveal the particular information relevant to her claims of harassment and retaliation. So like I said, he's not like quashing the subpoenas in whole, just that part where it was like way overly broad. Okay, hang on. Okay, we got through that. The Wayfarer parties may assert a privacy interest in their own phone records, but they have not provided any basis for asserting an interest in the communications of non-parties. Therefore, the Wayfarer party's motion is denied as to the portions of the subpoenas which seek the phone records of non-parties. So the motion to quash is granted in part and denied in part. Okay. And I'm pretty sure that's all we got right now, unless there's anything that just came in while we were doing that. Give me 1 second to check. Okay. Yep. That's all we got for right now. But like I said, I'm going to keep an eye on the docket, guys. And I'm going to post this document on X, and I'm going to post this document on my YouTube page under posts. So yeah. Oh, bring on Omar, Tilted Lawyer. I would love to, but I think it's like 7 o'clock where he is. He's probably getting his kids ready for school or something. So we need a lawyer's interpretation. I'm sure we're going to get one. Thanks, everybody. I really appreciate you being here. And I will talk to you later today for sure. Like I said, I am looking out for that response from the New York Times, which I believe is due today. The docket did list today as the due date. So we'll see how that goes. Oh, Harry says this is a civil, not a criminal case. There is no guilty. In civil cases, the parties have to investigate their claims via discovery. That's true. So I've been, I've been kind of noticing that myself. Like when people say stuff like plead insanity or shit like that, I'm like, well, it's not that kind of trial, But yeah. Okay. Thanks, everybody. Can we have a quick summary of the document? I mean, the document's only 6 pages, so I would ask that you just maybe listen to it or, yeah. So also, like I said, I'll be posting it. So, hey, Bruce, how's it going? All right, guys, I gotta run. Get back to work. I was trying to see if there's anybody else covering this that I might be able to redirect you to now. Please don't forget to like this video for me. I would really appreciate it. Let's see. Oh yeah. I'll send you guys over to Dave. His the leaked audio podcast episode that he did is playing now. Okay. So say hi to my friend Dave for me. Send lots of bacons and tell him Lauren sent you. I will talk to you guys soon. Bye.